From Chicago's Can TV, a look at the week's events is reported in the newspapers, in the blogs and online, and on radio and TV. This is Chicago Newsroom.
And hello again. Welcome to another edition of Chicago Newsroom. What a week it's been. We've had appellate court rulings taking Rahm Emanuel off the ballot. We had another one that basically shut down the video poker and the money going to all the construction projects in Illinois. Lots of things going on, so we've brought some real experts in to talk about it, and we got to get right down to work. Eric Zorn joining us for the second time on the program today. And Eric, when we do our 25th anniversary program, you'll be on it, and you will even then be able to say you were on the first edition of Chicago Newsroom. Glad to have you with us again today. Alden Loury is, Eric, by the way, is a blogger and columnist for the Chicago Tribune, in case you didn't know that, or is it columnist and blogger, whichever you prefer?
Either one.
Either one works. Alden Loury is joining us again for the second time. Glad to have you with us, Alden. He's the publisher of the Chicago Reporter, and they've been doing some stellar stuff on the disparity of joblessness in Chicago and a lot of other great things that I hope we'll be able to weave into our conversation today. And I don't think either of our guests would mind if I said, and our special guest today is Joe Morris joining us. Joe Morris is an attorney in Chicago, but also known as a hearing officer for the Chicago Board of Election Commissioners. That's kind of a part-time gig for you, I suppose, right? Yeah.
Once a year.
Once a year. And this time he became the household celebrity because you pulled this guy, Rahm Emanuel. You had to do his hearing, I understand, right? So how did that happen? Let's start with that. How did you end up being the guy who had to do that days-long hearing?
Well, one takes the cases as they're assigned to one. I've been sitting as a hearing officer more or less every year. There's an election in Chicago just about every year, and there's almost always ballot access litigation in election season in Illinois. I've been sitting as a hearing officer for the Chicago Board of Elections for about 10 years, and this year was a record year with
it sure was.
With a mayor to be elected, a city clerk, a city treasurer, and 50 aldermen, and lots of vacancies and lots of fresh faces. There's a record number of candidacies, and there was a record number of objections filed. And people have the right under the Illinois Election Code to file objections if they think that there's something wrong with candidacy papers. But this year records were set. 425 separate objections were filed. 32 of them were addressed to the candidacy papers of Rahm Emanuel. And this year, the workload being what it was, those 32 cases were all assigned to me and no others. So I didn't have room in my docket for any other cases. I had the 32 Emanuel cases. How the decision was made to assign the case to me, I don't know. That's a decision that the board made, but I assume it's because I've been around the track for a while. I've had a few.
But still, when you open the email or the envelope or something, there must have been a moment of like, oh no, what am I in for here?
Well, the questions of law involved in such a case are always interesting, but never frightening. What was somewhat daunting about this case was looking at the papers and realizing that most of the challenges were either identical or overlapped, which left a very interesting question of sort of judicial management, of case management. Right. Should we have 32 separate trials that are going to involve more or less the same issues and certainly the same witnesses, bringing in the witnesses 32 different times, likely to be 32 different days, in a context where there's no time to spare. Between the time for filing and the time for an election, there's really just a few weeks.
Yeah, yeah.
And if we at the Chicago Board of Elections are to do our jobs and still leave room for judicial review, and as everybody now knows, judicial review of these decisions is a very important part of the process.
Right, yeah.
Means that we can't dally in doing the administrative part of the process.
Well, we can't dally here either because we've got a lot to deal with today and where things are at. We're breaking our rule, by the way, of no portable electronics on the table. Eric has got his BlackBerry here just in case they decide to do it while we're doing the show today. He'll get the alert and we'll be able to react. But I mean, Eric, this was something that I think shocked pretty much everybody when the appellate court threw Rahm Emanuel off the ballot, and for a while there, he was literally off of the ballot.
Well, I guess it shocked. I mean, it certainly shocked me. I guess there were a lot of people in the legal community who weren't shocked by it, who thought that there was a legitimate conflict in the law. And I read Joe's opinion in the case, and I was persuaded by it. I remain persuaded by the defense in the appellate court decision. And part of that, I'm not a lawyer, so part of that comes out, my interpretation of it comes out of my feeling that that in these cases where there might be a close call, that one should err on the side of access to the ballot. That it's not just the rights of the candidates that we're talking about; it's the rights of the voters to vote.
Err on the side of democracy.
Democracy.
Like,
what did I say? Ballot access for the people. So that yeah. I mean, I understand. I understand as a layman. I understand this debate over what residency means and so on. But as I read these opinions and I look at these laws and I think, well, my sense is that we should, when possible, err on that side, and that's what I felt that certainly that Justice Lamkin did and Mr. Morris did as well. So I was surprised to see it go the other way. Yes.
Alden, can we bring you in on this, because there have been some very interesting alignments. I was listening for quite a while yesterday, or the last couple of days, to Cliff Kelly, and Mary Mitchell has written rather forcefully on this, and I think it's fair to categorize it as saying, oh, look at this, the guy with all the money and the power got knocked off the ballot, instead of it being the sort of the powerless who get treated this way all the time. Why do we have to be so sympathetic to Rahm Emanuel? The law is the law.
Yeah, I mean, as Eric was saying, there's a question about really what the law is here or how you interpret the law, but yeah, there's a long history of particularly in the aldermanic races, of the underfunded and the unheard getting booted off. And it's almost a matter of course for aldermen that they challenge the petition, sometimes of every challenger that's on the ballot. Some of these folks are very well-meaning. Some of them are folks that have been around, have got a stake in the community, actually have very good political views and ideas, and in some respects understand what's happening in those wards better than the aldermen do, and they never make it on the ballot, or they make it on the ballot, but after spending weeks, sitting in front of Joe and others, in terms of their hearings, trying to argue their way back onto the ballot. So yeah, it is somewhat ironic that here's someone who typically doesn't have to worry about that kind of access problem,
who can fly a former president in,
to have to kind of make it in.
I wanted to ask Joe. I mean, one of the other hats that Joe wears, he's a conservative pundit, one of the town's best spokesmen for the conservative cause. If you could put that hat on and take off the hat as the lawyer who hears these things, do you fundamentally agree or disagree with my notion that these ballot access laws are too tight, and that we need to open up the ballot more? We're picking nits and keeping people off the ballot.
Well, I have to be careful in answering your question, commenting on this. As a citizen, as a conservative, as a pundit, I would love to be discussing all these issues and the interplay of politics, partisan politics in all of this. But I have to say, this is a system of the rule of law. And people sitting in judicial or quasi-judicial positions like me, the Board of Elections, and the judges, I think really do try very hard to set aside the political questions and focus on the law, meaning taking texts seriously. You can see, reading my decision, you can see reading the appellate court opinions, that's what the deciders are doing. They're taking text and really faithfully trying to ascertain what they meant. Now, where do those texts come from? Those texts come from, in this case, the legislature and to some extent the state constitution. The legislature can fix this problem for the future. The legislature can what we have here is not to get too deeply into the legal technicalities, but a question of how do we read the Illinois Municipal Code, an enactment of the Illinois General Assembly, together with provisions of the Illinois Election Code, an enactment of the Illinois General Assembly. And what the judges are wrestling with is how to harmonize or reconcile seemingly inconsistent, or in any event ambiguous provisions of these enactments. The legislature can fix that by amending either or both codes and harmonizing them itself as it sees fit.
Right. Joe, I'm going to have a hard time phrasing this question because I don't really understand what my own question is, but it appears to me, from everything we've been reading, all in the media in the last week, that the appellate court took things further than they ever, or than the law has been interpreted in the past, if you can follow what I'm saying. My understanding of it has been that in the past, kind of like Eric was saying, there was kind of a benefit of the doubt in these residency issues, but they seem to have drawn a bright line now and said you have to have physically been in the city for the last, or in the municipality or whatever it is for the last year. Again, I may be wrong in my assumption, but is it true that this ruling of the appellate court has solidified something that was not solid before?
I think that's fair within certain boundaries, and let me explain that. First of all, the larger point, we have over the course of our lifetimes seen an evolution in the law in Illinois in particular, but across the country. Whereas a generation or two ago, ballot access rules were often applied very, very strictly. The higher courts, including our Illinois Supreme Court in various cases in recent years, have made it clear that a more latitudinarian philosophy should prevail, and if there's a doubt, the doubt should be resolved in favor of ballot access rather than resolving the doubt against ballot access. And that's a kind of a change in the spirit of the thing in the last 20 years. In this particular case, we have a state statute provision of the municipal code which imposes a residency or one-year residency requirement to run for mayor. What does that mean? What does it mean to be in residence for a year? That particular statute, it turns out, has never before been parsed. It's never, that particular language of that statute has never before been parsed.
That's incredible.
Instead, the related statute, the provision of the Illinois election code, has a residency requirement to be an elector, a voter. And one of the qualifications to run for mayor in the municipal code is that one be a qualified elector, a qualified voter. So what has happened over the course of the last many years is the Chicago Board of Elections and the courts that have dealt with this question have read the residency standard of the election code into the residency requirement of the municipal code, and just assumed that they were the same, and applied the tests that one would apply for residency under the election code to an elector to the question of residency under the municipal code. What the majority in the appellate court did in its decision in this case is say, stop. We're going to unpack the provisions of the municipal code. Not been done before. We're going to take it, deconstruct it down to the ground level and read it back up again to see what it means. That's a perfectly legitimate way to do judgecraft. The resulting opinion is scholarly, to be sure. It is a scholarly opinion on which scholars and lawyers and judges can and do differ, as Justice Lamkin's dissent makes clear.
Which side of that opinion do you fall on when you read those two?
Well, my decision, I think I have to say, speaks for itself. And I followed the prior precedent, the prior practice of the prior rule of construction of in this situation of applying the residency test for electors that's found in the election code.
Well, one of your colleagues, and I don't remember who it was on Chicago Tonight the other night, and he said that he agreed with your ruling, and he felt that your ruling was correct. However, if he were in the position of hearing the Emanuel case today, in light of the ruling by the appellate court, he would rule the other way because of the appellate court. Do you share that? That
colleague of mine is Professor William Cressy of St. Xavier University, who has the luxury of being uninvolved in this. His work for the board is over. His decisions are not here under review. I think it would be unseemly for me to be lecturing the Supreme Court of Illinois on how I would decide a case that I've already decided were I now a member of the Supreme Court of Illinois. I have set out my views in some detail in my decision, for good or for ill, and what utility that has been to the appellate court and to the Supreme Court is for them to decide.
But if this case had been an almost identical case had been decided a year ago by the appellate court, would your ruling then have been different because of the appellate court decision? If you can reverse those two, does the appellate court decision change your decision in retrospect?
Well, of course. If the appellate court decision issued within the last week were the last word from the courts in this case, and I were sitting as a hearing officer, the absolute lowest rung of the judicial or quasi-judicial process, I would be guided. I would be my work would necessarily be controlled by that decision, because that's what
jurisprudence.
That's what hearing officers do.
Right.
Hearing officers apply the law that's been determined by others, the legislature, or if there's ambiguity or some question how to interpret what the legislature did, the higher courts.
I noticed that the majority in the Supreme Court, I'm sorry, the appellate court decision refers back to a definition or an excuse for residency that goes back to like 1901. I think Illinois Supreme Court case of 1901, talking about why it's important for someone to be a resident, and it talks about being in the community and talking to people and so on. Do you think those? I mean, and this is not a legal question really, but more of just a common sense thing. Is it as important anymore for someone to actually be physically present in a community, given all the technology we have to stay in touch with issues and people?
I know one of the things that I kind of fall back on, and this is in response to your question, it's the notion that you establish residency and then you maintain it. So even if you're away temporarily, you don't lose the residency. And I think that's kind of the heart of Emanuel's defense here. And in a common sense way, I think there's merit to that. I mean, if you've spent 20 years in a community, working there, representing some portion of the community in Congress or in other ways, and then you're away for some period of time, I think you can still say, I'm vested in this community. No, I have not lived here in the past year, but I've established my roots here, my family's here, I'm grounded here. And so I'm a part of this community, I care about this community. And so when I'm running for office to be the leader of this city, no one can say that I haven't kind of paid my dues to make that.
Eric's question is an excellent one in the historical context. The question of residency and its application to holding office goes all the way back to our first Constitution, the early part of the 19th century. And actually there were several 19th century Illinois Supreme Court decisions that I cited in my decision. So the historical wrestling with these questions goes back a long way.
1818, I believe, right, in Illinois.
That's right. Under the circumstances, some thought experiments are kind of interesting. If, as the majority opinion of the appellate court seems to say, the only exception to the continuous unbroken residency requirement that appears to be how it reads the municipal code is the exception for persons in the armed services. There's no other exception. Justice Lampkin's dissent raises the interesting question, well, if we literally mean that, actually resides in Chicago in an unbroken way, actually resides in the municipality, does that mean that if one goes on within 12 months before the election, one goes on a 30-day vacation, a 2-week business trip? Imagine an incumbent mayor of Chicago going on a 1-week trade mission to China. Have those persons thereby forfeited their unbroken year of residence by sleeping outside the city?
The other question, though, that this military exemption brings up for me is if you say, well, you've got to be in the community to understand the community, that's why we have this law here.
As you raise
I raised this online. It's like, well, if you're overseas in the military, I mean, no offense to anyone who's in the military, but you're not.
Why is that an exception?
If that's an exception, then the rule is incoherent, because it just means that we're therefore punishing someone or rewarding them by being where they are. And that brings me back to this other question, which is, aren't the rights of the voters here also so inextricably tied up in the rights of a candidate? Like, isn't, as someone I interviewed the other day said something like, your right as a voter is just completely intertwined with the right of someone, of your right to vote for somebody and that person's right to run for office.
Let's try to move on a little bit if we can, because after all, this entire conversation could be completely obviated by a ruling any moment or sometime later today. I don't suppose anybody here wants to take a guess at what the Illinois Supreme Court's going to do.
I think ultimately they're gonna allow him to remain on the ballot.
You think so?
Yeah.
So do I. I can't see how it could be any
I have
other
no
way.
problem making errant predictions. I do it all the time.
You love it. I know.
I do. I'll say I think that they will. I think they will, and I think that they will keep him on the ballot. But I hope that however they rule, that it is like 6-1 or 7-0. That I think that this kind of decision should not. If it's 4-3, it's going to be. It's going to really tear it at this. At the system. I think that I hope that they can get together and come up with a ruling one way or the other. Right. That's strong.
The board of directors has voted 4-3 to wish the CEO a happy birthday.
Yes, exactly.
Right.
So there's added drama if Ann Burke is if she's the fourth.
I just think it's problematic if it's I mean, I don't know, and if you want to comment on this at all, Joe, but do you agree that a 4-3 ruling is with the stakes this high is?
I think it would be unseemly for me to comment on that.
All right.
Understood. There are just so many things that I want to keep talking about with this, but let's delve into politics a little bit here. Assuming, as I think most of us here do, and I'm sure most of the audience does, that the Supreme Court will overturn this and Rahm Emanuel will be on the ballot, doesn't it just even strengthen his already his juggernautian candidacy even further? That now he's been this victim, he's been run over by the man. Here is just this little guy trying to serve the public, and he can't get a break.
Just
from
a little
man.
ballet student.
That's right. Just a little guy from Wilmette trying to be mayor.
Who's got his bike stolen when he was a kid. And
That's
now
right.
this.
And he's just been victimized all his life, and this is just another one of these terrible things that's happened to him. I mean, doesn't it just make it all the more certain that he's just right in there on April 20 or February 22nd?
I think so. I think that if he is put on the ballot, then the election is over on February 22nd. But I've thought all along that he's going to win on February 22nd outright. And this is pivotal. If he doesn't win, I'll go further out and make another prediction, which is if he's kicked off the ballot, I think Gary Chico is the one who benefits most from this and probably gets most of that support. The reason being, as one of my colleagues said yesterday, is we are looking to hire a CEO for the city of Chicago, and you look for someone who has that kind of affect, and certainly Gary Chico is sort of Emanuel light in that sense. I think by a lot of people who support Emanuel.
You know, it's an interesting. I'm sorry, Alden, but just one quick observation. It's something we were talking about a little bit last week when Mark Brown was on the show here too. That in the sense of whatever that thing is, that imagining the guy standing behind the podium and being the mayor on those really bad days when awful things happen and you need somebody to be in a leadership role. You know, it's a pretty good crop of candidates, because I can kind of imagine most of them doing it. But certainly Gary Chico has that look when you see him. There's that kind of confident, like, I've been there, I've done this, I can handle this, I got it, kind of thing. So I don't know. Yeah,
I mean, Chico's got an impressive resume. He's very polished, and I think people who aren't familiar with him, and you know, before we went on, I was saying this similar thing about Emanuel. People who don't know these folks. And journalists, you know, following them, you know, we're hanging on every word, but most voters don't really know a great deal about these folks. And so that outward appearance, I think, you know, can win a lot of support. And I think both of those men have this steely kind of appearance that may engender confidence in people. One of the things I think is interesting about Emanuel's campaign with all of this, and Eric, I would agree wholeheartedly that for the most part, the question hasn't been, you know, if Emanuel's going to win, it's when he's going to win. Does he win in February or does he win in April? But I think this whole ordeal has kind of invigorated that campaign. I mean, he's pretty much been on cruise control up until now, and we've seen a lot more kind of activity and action out of not just his campaign, but the folks who are supporting him publicly. I think one of the latest polls that came out for the first time showed him actually with 50%, greater than 50% of support in the poll numbers. It's the first time that we've seen that. And so if he does remain on the ballot, I think he's in good position to put this thing away.
One of the issues that's coming up a lot is this business with residency and firefighters and police officers.
Yes, right.
And all the candidates have been asked for their views on that, and are they going to change that? And Joe, do you see any connection between the residency issue for police and firefighters and the residency issue for political candidates?
The connection is that the same word appears, but people have to be careful. A word means what it means in context. A word means what the legislature or the creator of the text meant when the word was inserted, and that's what courts do. And it's not uncommon for courts to find that a word means something here in this legislative context, and it means something completely different when it's used over here. A lot of factors go into deciding that. I hasten to say, you will note conspicuously, I've said nothing about the candidates or their merits or the political questions here.
Duly noted.
Thank you. Precisely because I'm representing here sort of the adjudicative side of this question. We really are a system of laws rather than of men, and try to do that. And from everything I have seen in this process, from my role on up, All of the people in judicial or quasi-judicial roles have been behaving exactly that way. Let me hasten to say that there was absolutely no attempt whatsoever by anybody, anywhere, in any way, to influence my decision at the bottom rung of this process, except what the whole world saw taking place in public, at the public hearing, the evidence and the arguments that were made out in public, in the oral arguments and the briefs and so forth. Other than that, it was a pristine process. There was no other communication by anybody with me.
When we first planned this show, Alden, you were the first person we booked for the show because we wanted to talk about these issues, the issues that have not been raised in the campaign. Here we are once again. We're down to our last minute. We're almost finished. I apologize sincerely to you, but these, events have kind of taken the place. What are the 2 or 3 things that you wish could be talked about in this campaign that it's probably too late now, but what have we missed?
I think most of the real pertinent issues in the city have been touched on in some form or fashion, but there needs to be a very hard conversation and plan put forth about employment. To me, that is the #1 issue. A lot of the reporting and analysis that we've done has really kind of looked at as you mentioned at the top of the show, the disproportion and joblessness. But on the south and west sides, you've had depression-like unemployment figures, not just since the recession. You've had them since the 1980s. And one of the core criticisms from people in those communities with the Daley administration has been the inability of the administration to really kind of turn that economic situation around. And regardless of all of the controversy around a consensus candidate, whoever becomes mayor, black, white, otherwise, needs to really deal with that issue in some form or fashion. These communities have really been languishing for decades now.
Can it be dealt with by a mayor? What can a mayor do?
Well, I mean, if I had a firm answer to that, I would probably be in the wrong business.
You'd be running for mayor.
I certainly think, one thing you can certainly say is that investment, and true investment, and Daley has put a lot of money and a lot of resources into addressing a number of things, but in my opinion, I've always felt like there's been some added dimension to that. The tear down of public housing, the Renaissance 2010 plan, those things have merits on their own, but they've always seemed to have some kind of ulterior motive to them. Education really needs to be rethought and redone in these neighborhoods, and there actually needs to be employment available for people who, when those manufacturing jobs stuff, we've never found any real replacement for them. For people who, I wouldn't even say low skill, but for people who are going to finish their education with a high school degree and maybe a year or two of college. And the mechanism getting folks on the south and west sides of Chicago in particular to those kinds of jobs, we've never been able to find what that bridge is. And we've brought in the tech jobs, we've brought in Boeing, we brought in a number of others, but we haven't figured out a way to bring in the kind of jobs that suit the skills and the needs of those.
So what's the BlackBerry report?
Nothing on the
new?
BlackBerry, no.
Good, so we can go to press saying that we still don't know what the Illinois Supreme Court is going to do. Eric Zorn, thank you so much for being with us again today. Alden Loury, he's the publisher of the Chicago Reporter, and we're really glad to have you on the program here today. And joining us for the first time, Joe Morris, hearing officer for the Chicago Board of Election Commissioners, attorney, pundit, former official of the Ronald Reagan administration, and someone we really hope will come back and be on the show a bunch more times. Okay?
Thanks, Ken.
I'm Ken Davis. Thanks very much for watching. You've been watching Chicago Newsroom, which is a community service of CAN TV. You can find us here on cable, but you can also see this and other programs online at cantv.blip.tv. You can see us on iTunes. You can watch us on your iPod. We're everywhere. But also, don't forget that CAN TV is also the home for all the mayoral campaign or the candidate debates going on at 5 o'clock, CAN TV 19, leading up to the election. It is every Sunday at 5 o'clock. Check it out. It's really worth watching. There's one tonight on Channel 9, right? Yes. WGN. Thanks for watching. See you next time.